Hello and welcome to the Ken Vercammen Law Office Legal Podcast. This edition, we're going to talk about probate, estates, and in particular, the transfer of a deed. So, typically, the executor of the estate will what's called probate the will. There is a form that's typically filed with the surrogate's office, the surrogate information sheet. The attorney will fill that out and fax or email it to the county surrogate with a copy of the will, copy of the death certificate. That way, the surrogate can prepare the paperwork. So when the client goes to the surrogate's office, or some surrogates will actually email to the attorney's office, the person can sign in front of an attorney who's authorized to take an oath similar to a notary. Get sent to the surrogate's office. Then with the original will, the original death certificate, check for about $160, and that way executor gets the paperwork saying, okay, you're the executor, you're the captain of the ship. The executor next has the attorney send out a notice of probate to everyone who's a beneficiary in the will, plus everyone who would have inherited if there's no will. In New Jersey, the executor is thereafter not supervised by the county surrogate's office. It's their job to carry out the terms of the will. The attorney will typically file the New Jersey inheritance tax return, even if there's no inheritance tax due. That way, the tax waivers can be obtained. If there's a deed and the property is going to a family member, the attorney will prepare deed, affidavit of title, seller's residency form, the affidavit of exemption, so there's no tax that's due for the real estate transfer, and that's filed with the county clerk together with a check. I think it's a better practice just to have the executor, or whoever the beneficiary, hand deliver it to the county clerk so that it's in their hands. They can look at it, make sure the papers are okay, and have everything filed. The deed typically will say record and return to, and it's either the law office or the person that is receiving the property. Once the assets are liquidated, the executor will prepare an informal accounting, email it to all the beneficiaries. Then the attorney will prepare documents called a release or a funding bond, and that gets sent to all the different beneficiaries. If all the beneficiaries sign the release or funding bond, when there's a will, then the surrogate can the executor can pay everyone their money. Typically, a couple thousand is held just in case there's a small unknown debt. However, if any of the beneficiaries don't sign, then there has to be a complaint order show cause filed by the surrogate's office and then has to be determined by a superior court judge, and that'll delay everyone getting their money for 6 months, 16 months, depending upon the county, and the surrogate charges very high fees for that. For more information on probate, visit website njlaws.com, and for representation, contact Kenneth Vercammen's office in Edison at 732-572-0500. Thank you.